my sister in this movement, Mona Sinha, who is chair of the Fund for Women's Equality. Mona?
Thank you, Kimberly, and welcome everybody. It's so lovely to see so many people join us to figure out what's next. As I was reflecting on this morning, all I could think about was the beautiful poem read by Amanda Gorman during inauguration. And to quote her, she says, "We are a nation that isn't broken, but simply unfinished." And the work that we have ahead of us in the unfinished work of equal rights is now time to finish. So we're happy to have so many wonderful leaders join us, activists, the beautiful Alyssa Milano, who's always been a big supporter of our work. So let's come together and form a union that has purpose. Let's set our differences aside. Let's cast away all things unequal that have shown up so brightly during this bizarre past year that we have faced in our lives. And let's really create equality and opportunity for everyone in our democracy to thrive. So with that message, I hand over to Alyssa, who will add her beautiful words of welcome.
Hello, everyone. Thank you so much for being here. It seems like every event we do for the Equal Rights Amendment grows a little bit each time, and that's super, super exciting. Thank you to Mona and Carol and the ERA Coalition and Kimberly Peeler-Allen and all the attorney generals that are here that recognize that this is such an important time and it's such an exciting time because I feel like for the first time in this fight for me, and I've only been, fighting this fight for, I don't know, maybe 4 or 5 years. The first time in our lives, we are right on the cusp of having equal rights for women in the Constitution. Generations of women and allies have been fighting for this, and it's right here. We're so close. But of course, we also still are living in a world of uncertainty, because surely someone in the Senate is almost certainly going to filibuster the legislation necessary for its adoption. And that's why, despite the fact that we've been fighting for a century, we need to fight even harder now. That's why events like today are so important, so that we can learn what's next. We can learn what we should all be fighting for and all be on the same page and echo like millions of voices, like the millions of voices that we are. So I'm humbled to be a part of this beautiful event today, and honored to be just standing alongside of each of you and the many luminaries who are taking part and doing their part in making this a reality for future generations of women. So thank you so much.
Thank you so much, Alyssa. And Alyssa can really remember when there might have been 3 or 4 of us in the room. Yes. So she speaks from experience. And so we're delighted that we have so many of you. Kimberly and Mona, thank you for, as always, for your leadership. And thanks to everyone for being here today. I'm Carol Jenkins. I'm President and CEO of the ERA Coalition and the Fund for Women's Equality, with over 120 organizations and growing day by day, organization members representing the millions of people in this country who have said that they want unquestionably equality for all. Our session is being recorded today, and if you have questions, they can go in the chat, or you can raise your hand and we'll try to recognize you, but please remember to unmute yourself when recognized. We all know that by now. Oh, the many, many Zooms, muting and unmuting. We're thrilled that you're here today. So we've been pursuing the many paths to the ERA, the courts, the Congress, the White House, and we're now looking forward to putting it into practice. We think that we're just that close. So we will talk about our plans for the near future, the far future, implementing the Equal Rights Amendment. We have met the requirement set out in Article 5 of the Constitution, passage by 2/3 of Congress, That happened in 1972, ratification by 38 states. That happened last year. The archivist, whose clerical job it is to publish the amendment, has refused to do so based on instructions from the Trump Department of Justice. The 3 attorneys general of the final states to ratify sued the archivist to compel him to do so. The coalition stood with the attorneys general the day that they announced their suit, and we helped organize some 12 amicus briefs in support of the case and wrote the women's movement brief. We are very pleased to have those attorneys general with us today. General Mark Herring, Virginia Attorney General, representing the 38th and final state required to ratify the ERA, and that took place on January 27th of 2020. General Kwame Raoul, Illinois Attorney General, representing the 37th state to ratify in 2018, and General Aaron Ford, Nevada Attorney General, representing the 36th state to ratify in 2017. I think he did that with Senator Pat Spearman. But let us begin with General Mark Herring with some comments, and we'll go to each Attorney General. Thank you so much for being here today.
Well, Carol, thank you so much for the warm welcome. And first of all, I would just like to say a great big thank you to everyone who's on the call and for being here. And thank you for everyone who is a part of the Ehri Coalition. Thank you for your advocacy and your activism and your organizing, because it really makes a difference. And you know, as all of us on this call know, after more than 230 years, the Constitution finally declares once and for all that women in America have equal rights under the law, and that equality of rights under the law shall not be denied or abridged on account of sex. And it's hard to believe that for 150 years, our nation's founding document did not even acknowledge women. And that changed in 1920, when the concept of equality among the sexes first appeared in the Constitution for the first time, but only in the limited context of expanding the right to vote. But now, 100 years after that, the ERA is the 28th Amendment to the United States Constitution, and the law will never again treat any American like a second-class citizen on account of their sex. And as Carol mentioned, it was just over a year ago today that Virginia made history in becoming the 38th and final state to ratify the ERA. So that part of the work is done. Every constitutional requirement's been fulfilled, and the ERA is now a part of the Constitution as the 28th Amendment. And I cannot tell you how proud I am of my home state of Virginia that we put us over the top. Would like to have it happened a long time ago, but you know, at least we got it done. And I was so proud when that happened. Unfortunately, the forces that have tried to deny women the equal protection of the law for centuries have not been fully vanquished yet. And one thing I know is that this movement and the women of America have shown time and time again that if you throw up roadblocks, they're going to go over them, they're going to go around them, or just straight through. Whatever it takes, they will do. And last year, after it was becoming clear that Virginia was going to ratify the ERA, adding it to the Constitution, the Trump administration went to work trying to nullify the will of millions and millions of Americans as spoken through their elected representatives, and went to work to try to undermine that work. And fair to say, we are not going to accept that. We haven't accepted that. And that's why we filed suit to ensure that the ERA is recognized as the 28th Amendment to the Constitution, and that the foundational document of our nation recognizes that we are all equal. So we filed a complaint in the District Court of the District of Columbia against the archivist, and seeking a declaration that the ERA is a valid part of the Constitution, and ordering that the archivist perform his ministerial duty under the law and recognize it as a part of the Constitution that is valid for all intents and purposes. With this lawsuit, I had a tremendous honor of picking up the baton, if you will, from millions of citizen advocates and organizations and others who have led this battle for generations. Really glad to have my friends and colleagues Attorney General Kwame Raoul of Illinois, Attorney General Aaron Ford of Nevada, as well as an army of allies, many of whom are on this call with us today in this fight alongside of us. Since filing our lawsuit last year, we have received support from around the country. And this support has been critical in our fight because I feel like the weight of history, is really with us on this case, both as Attorney General and personally, for a couple of reasons. Too often, Virginia has been on the wrong side of history, especially when it comes to landmark civil rights cases. And I can rattle a bunch of them off. We had a case that desegregating schools in Virginia led by Barbara Johns. It became one of the Brown versus Board of Education cases, and the Attorney General at the time fought her every step of the way to the Supreme Court with interracial marriage and the Loving versus Virginia case in the 60s. Again, the Attorney General at that time fought all the way to the Supreme Court to defend that injustice. And even more recently, in the 90s in the VMI case. So many times we were on the wrong side, but we have shown a whole different vision of what an Attorney General can do over the last 7 years. And it's important for the Attorney General to be on the side of the people fighting to protect people's rights. For me personally, this also fulfills a lifelong dream of a single mom who raised me. I was raised by a single mom. I have one sibling, an older sister, and they were fierce advocates of the ERA back in the 1970s when I was a teenager growing up. And my mom told me a lot of stories about hardships that she's had to confront. One of them, she was in those days, she was a flight attendant. In those days, they were called stewardesses, and she flew for an airline in the 1950s, and she loved that job. But then when she got engaged to be married, that had to be the end of that job for her because they had a no marriage rule. And I heard that story growing up over and over, and then just also witnessed the hurdles that she had put in front of her. So while we've come a long, long way since then, as a society and a country, we know that women still experience discrimination every single day. And so don't let anyone tell you the ERA doesn't matter. It matters for millions of women who will finally enjoy the constitutional protections they deserve. And it matters for generations to come, who will be able to look at the Constitution and see that the founding document of our country protects them. I took on this fight because equality matters. Equality is always worth fighting for. So, for the moment, our fight continues, and we've picked up some opponents along the way who believe it's more important to fight against equality than for it. But throughout history, we have seen that equality prevails, and it will in this instance too. So thank you for having me today and talking about what comes next. And also thank you again for your advocacy and activism and organizing to make sure that the Equal Rights Amendment is recognized as the 28th Amendment to the Constitution.
Thank you so much, Attorney General Herring. And now next, Attorney General Kwame Raoul. I think you may need to unmute, General.
I should know
there
how
we
to.
go.
I should know how to operate these things by now.
And I get to boss a general around. No, that's thank you so much for being with us.
Well, thank you for having me. Good to see you again. Good to connect virtually. I greet you from my kitchen counter in my home in Chicago, Illinois, where we're all snowed in. I'm home alone with my daughter. And like so many young adults, my daughter, a college junior, is living at home, studying remotely during the pandemic. This has given me the happy privilege of talking with her about her plans and vision for the future. She's preparing to take the LSAT and seek admission to law school. I couldn't be prouder and more hopeful. I thought of my daughter, of course, when as a member of the Illinois Senate, I voted to ratify the Equal Rights Amendment in 2018. She should be able to embark upon her legal career or any career of her choosing with her rights and equity enshrined in the Constitution without facing obstacles placed in her path by gender discrimination. I am proud that Illinois' ratification was one of the final 3 needed to protect the rights of all Americans, regardless of gender, in our foundational document. My colleagues in Nevada and Virginia rounded out the roster of 38 state legislatures that have voted to ratify the ERA. In my current position, I'm honored to fight in court alongside General Ford and General Herring to make sure the amendment we ratified and its principles that it stands for are added to the text of the Constitution as the law requires. I also support the bipartisan effort in Congress to pass legislation removing the purported 1982 deadline for ratification. Litigation will likely continue as long as those states whose legislatures attempted to rescind the previous ratification votes challenge the amendment's validity. But such a clear expression of the current Congress's intent would matter and would weaken their argument. I look forward to a day when our focus is not just on putting these words into our Constitution, but on fulfilling their promise of equality. I thank you all for your collective effort, and we continue to fight on.
Thank you so much, General. General Aaron Ford of Nevada.
Well, I think it's morning to me, so good morning to everybody else. I am not as well dressed as my colleagues from Virginia or Illinois. He's got a pocket square, and that's my fraternity brother. Of course, he looks real good. Cap out facade, that's how we do it, generally speaking. But I'm still the best dressed because of my mask. Take a look at that. That says ERA on it, and the timing of this mask couldn't be more perfect. I got here this morning, and Jerry Burden, the president of the local chapter of the National Organization for Women, had mailed that to me. And so perfect timing for the conversation. And I am glad to be here to have the conversation. Listen, substantively speaking, I can't offer much more than what Generals Herring and Raoul have. What I will do is quickly just talk a little bit about what this means personally to me. I recognize that I'm late to the game. Not because I didn't want to be earlier, but as a matter of the accident of birth, born in 1972, soon after the ERA was submitted to the states for consideration, is when I was born. And I got here as soon as I could, I like to say. I recall in 2015, where my colleague, Senator Pat Spearman, and I worked. I was the minority leader of the state Senate at the time, and we worked to try to convince the majority party to entertain ratification of the ERA. We couldn't even get a hearing. The argument was that the time frame for ratifying it had passed, and it was a fruitless effort, a meritless effort, and therefore they wouldn't even give it a conversation. 2 years later, probably by no coincidence, they lost the majority and we won the majority. I became the majority leader of the state Senate, and I was able to work with Senator Pat Spearman yet again to introduce the ERA for ratification. Similar to General Raoul, I'm proud of the fact that our state restarted the count, but I'm likewise dismayed in the fact that it took us so many years to get to the point where we could get to this point. I use my words in talking about equal rights very deliberately. Nevada has shown a penchant for being progressive, albeit not in this particular instance. Well before the 1920 recognition of the right to vote for women, Nevada had in 1914 already done so. And understand my words, I said recognized, not granted, because I believe that we're all born with inalienable rights. One of those is the right to vote. Another of which is the right to be treated equally under the law. And so what we're looking for through the adoption, through the ratification, through the acknowledgement of the ERA is a final recognition of what has existed since the conception and well before the inception of our democratic republic. And so I'm proud to stand with my colleagues, Generals Herring and Raoul, as we litigate this issue. We do believe it's a ministerial duty, and it should be taken care of relatively quickly. I'm proud to see that we have parallel tracks running where Congress is looking to help us on that front, and where we are again in court working, and where I think Kimberly said that we as the AGs are leading the fight. I beg to differ. We are part of this fight. We are part of a grander, larger army that has been fighting for equality, fighting for the recognition for equality for, as someone said, generations. And listen, I've raised 3 sons and a nephew, and they all know the importance of equality. I raised them as men to recognize that they are equal and no better than anyone else, especially the women in our country. And so I look forward to continuing this fight. I look forward to representing as well as I can. My wife, appreciates this effort. My mother appreciates this effort. My grandparents appreciate this effort. And I am again delighted to be in this fight with all of you. So with that, I will tender the mic back and say as a parting note that again, I'm here as a part of this army and will continue to fight alongside you. Thank you.
Thank you so much. And that really was a coup. Did you say that it was Jerry Burton who sent you that mask?
It was Jerry Burton. Her card was in the mask, absolutely.
Thank you, Jerry, one of our coalition members, one of our most active. I do want to say that when we were reaching out to the Attorney General, I called Senator Pat Spearman, who, as you may know, was in the leadership of first ratifying Nevada. It was just an incredible thing. And I said to her, Pat, I'm trying to reach the Attorney General. She said, hold on, I'll call him, which she did. And I was like, oh, General, thank you. We need your voice. And thank you for being here today. If you have a minute to stay, I want to introduce Linda Coberly, who is the chair of the ERA Coalition Legal Task Force. She's also managing partner of Winston & Strawn Chicago office. She's on the firm's executive committee and chairs the firm's appellate and critical motions department. She testified in the Illinois ratification process. And Jessica Neuwirth, the ERA Coalition co-founder and president emerita of the Coalition and Fund, the author of Equal Means Equal, Why the Time for the Equal Rights Amendment is Now. And she chairs Hunter College's Human Rights Programs. Linda and Jessica, I turn it over to you. You may have a question or two for the generals. I understand that they do have limited time.
Great, and I'm thrilled to be sharing the screen with the attorneys general. Like Attorney General Raoul, I am sitting in frigid Chicago, where we are inundated with snow, as I understand much of the country is at this point. I'm really proud to be part of this effort, and am happy to answer questions that folks on the call have about the status of the ERA. The lawsuit that the attorneys general are prosecuting is a really important part of this effort. As we've all discussed, and as Attorney General Herring said in his introductory comments, the ERA is done, right? It's done. It's already satisfied all the requirements of the Constitution to become our 28th Amendment. So where does that leave us? Well, there are opponents who raise 2 issues. Both of which could be resolved in the lawsuit that the attorneys general are prosecuting right now in the District of Columbia. First of all, the court could determine that, and the parties have asked the court to determine the validity of the time limit. The time limit contained in the preamble to the Equal Rights Amendment in 1972. Provided purported to provide a limited amount of time for states to ratify. The argument in the litigation is that Congress can't unilaterally change the requirements of Article 5. The requirements of Article 5 are constitutional, and those requirements are set forth in Article 5, and they can't be changed by unilaterally by Congress in the preamble. There's also an argument in that case about the states that have attempted to rescind or limit their prior ratifications. And of course, the court is also facing arguments about that. And there's very strong historical precedent for the idea that a ratification, once voted on by a state legislature, can't be taken back. So those issues are all presented in the litigation. And I understand, and I think the attorneys general can confirm, we're still waiting for an argument in that case. No argument has been set in that case. And it's possible that the judge is just waiting. It sometimes takes a long time to resolve motions. It's also possible that the judge is waiting for some action, some other action by the Department of Justice, which is representing the archivist in the lawsuit. And so I suppose we will see what happens in respect to the Department of Justice's action. And meanwhile, the Congress is considering bills to remove the time limit. The bill in the House was passed last year. It has been re-upped with the new Congress, and in the Senate, it's bill number 1. It's Senate Joint Resolution number 1 to remove the time limit. And again, both bills have bipartisan sponsorship. Jessica, I'll turn it to you for any comments you have.
Great, thank you. And thanks and welcome to everyone. It's just great to be here with 3 such incredible heroes. And I want to start just by thanking the 3 of you, as well as Pat Spearman and all the advocates in Virginia, Illinois, and Nevada, who really took, when we started in 2013, took what was a very remote kind of dream and turned it into this reality in such a short time. And to just have the power of all of you and your offices behind this initiative is what I think is ultimately, helping us cross the finish line here. So thank you for that. My question for you is, with the new Biden administration, what are you hoping for in terms of both the archivist and the administration's position in the litigation?
Attorney General Herring, would you like to start?
Sure. I think it's still a little bit early to be able to make assessments about that. We still don't know who is going to be heading up the Office of Legal Counsel in the White House. We still don't know who is going to be heading up federal programs in the Department of Justice under the Biden administration. But I do think the potential to get legislation removing the deadline through Congress really opens up an opportunity to kind of reframe the landscape a little bit. While I don't think for a moment it's required or needed for Congress to do that, I do think it removes one of the arguments that the opponents have made. And that could also open up some potential changes in how the new Biden administration and its Department of Justice views the case, and could present maybe some opportunities for them to go back and take a look at one of the previous legal memos that reached the absolute wrong conclusion, and that maybe there's a more a different approach that is more consistent with legal precedent to help really shift the landscape in the court case, and that could really begin to change the posture of the case.
General Raoul?
Yeah, certainly. We've obviously, on a whole host of issues, have been anticipating a change of posture by the administration generally, by the Department of Justice, and certainly by a different Senate than existed maybe a month and a half ago. And collectively, as attorneys general, we have been talking about how we advocate on all of those issues, including the Equal Rights Amendment, as we engage in conversations, both on the legislative agenda as well as conversations that we may have with the executive branch and DOJ in particular. And so we're hopeful of a positive result as a result.
Thank you, General Ford.
Yeah, and ditto to those things. Again, I don't have much substantively to offer aside from what has already been said. More than cautiously optimistic, I am frankly optimistic that we will see a change in posture. The timing clearly is up to the administration, but I'm hopeful that it's sooner than later. What we are prepared for and had to be prepared for is the other set of litigation that's pending out there. I believe it's led by Alabama and others who are trying to say that the ratification should not be recognized, and that affirmative litigation will have to be something that we contend with. I know at least 25 attorneys general in this country, my fellow Democratic attorneys general, frankly, will line up in opposition to that, and maybe we will see a bipartisan effort as well. And we are, in fact, again, prepared to address those issues and stand steadfast behind ratification of the ERA. I must say, unfortunately, Carol, I'm going to have to leave. We are in the middle of our legislative session, and I have a bill to present, but I want to part by saying to you what I said to my team here on day 2 on the job after I was inaugurated. On January the 7th, 2019, that was the first day of my job. I can't say we were doing much. It was a lot of pomp and circumstance and gratitude and whatnot, but day 2 on the job, I introduced several areas of focus that we have in my office, one of which was the protection of constitutional rights. And I said right there in point blank that I believed that there should be 28 amendments and that I would work through my office to ensure that the Equal Rights Amendment was not only ratified at the end of the day, but ultimately recognized. And so that fight continues. Again, I am proud to work alongside my colleagues. I'm proud to work alongside you to ensure that we get that done. I'm here for the long haul. So whatever it is that I can do, please do let us know. And in the meantime, we will continue this fight. I have to leave, but thank you so much, Carol, for having me. And thank you all for receiving these comments. Take care.
Thank you so much. And in fact, we're going to release all of the generals who did give us a special part of the day and the program. We really appreciate it so much. We will be in touch and thank you. But Linda and Jessica, if you could, thank you all. And everybody's applauding for the great participation. Thank you.
Thank you for having us.
Linda
Yes,
and
thank you.
Jessica. Thanks. If you wanted to sort of wrap up, is there anything that, that we need to know going forward with the attorneys general with the case?
Sure, I'll just answer one very common question. I saw it in the chat and I've heard it before, and I'll just give a quick answer here, which is, do we still need the lawsuit if the Biden administration were to publish the amendment? And the answer is yes. Once an amendment becomes part of the Constitution, it's part of the Constitution. And actually, you don't need any additional action by the administrative branch or by the administrative offices or by the executive branch. So, if the archivist were to actually go ahead and publish the amendment, that would be fantastic. We would welcome that. That would be terrific. It doesn't by itself resolve the legal issues that someone's going to eventually have to resolve. And for that reason, the lawsuit and the dispute in the courts will almost certainly continue. If the archivist goes ahead and publishes, then it will be the state of Alabama and the other states who are still insisting that the publication should be invalidated or something like that, or taken back because of their efforts in the 1970s to rescind or limit their ratification. So the legal issues are still going to be in court, and they're still going to have to get resolved in some fashion. So I don't think a certification or a publication by the archivist will resolve that issue altogether. It also doesn't really shock me that we haven't heard anything yet from the Department of Justice. One of the really consistent themes that we've been hearing from the Biden administration is an effort to really distinguish itself from the Trump administration by allowing the Department of Justice some measure of independence. And so I don't think, unlike under the Trump administration, I don't think we're going to be seeing an effort by the Biden administration to give instructions to the Department of Justice. I think all indications are that they're going to really avoid doing that kind of thing. So I think we're just going to have to be patient and allow the process to play out within the Department of Justice. So those are just a few thoughts. Jessica, anything to add about that?
Yeah, I mean, I guess my thoughts are listening to the attorneys general. You can hear that even though their legal position is clear, they still would really love to see that legislation go through Congress. And I think that's where we have a really tremendous role to play. It will just take away a big issue in the litigation. It may not solve all the problems, same as what Linda said about the archivist. But I think the other part is how we got here with everybody's help, which has been so incredible, is through public awareness and public pressure. You know, we all know in our states, that's what we had to do. Nationally, that's what we had to do. It worked in the House to get that bill last year. Didn't work in the Senate. It hopefully will work in the Senate this year, and we'll get that bill. But I think in terms of the litigation and what Linda said, we also need to, I mean, the 27th Amendment, which many of you know, the Madison Amendment, that was never challenged in court. It took 200 years to get that ratified. Nobody ever challenged it in court. I think we need to really make it completely shameful for Alabama and other states to be contesting the Equal Rights Amendment in court. It's 24 words that are a no-brainer. And I just think we have to have a certain level of pressure there that's non-legal to support all of the work that's being done in litigation, to just say, who is going to stand up and oppose the ERA? Let's hear it. And we're not going to stand for that. So those are my parting thoughts.
Great, great. And our marching orders too. Thank you. Thank you, Jessica and Linda, so much. And we've been talking about the time limit. They used to call it a deadline, but we say, no, that sounds way too formal. They didn't really mean that. It's just a suggested time limit. That's our point of view. And we've been working in Congress to remove it. It was imposed on the ERA's introduction, the preamble, as Linda said. First it was 7 years, then another 3 years. Last year, the House of Representatives dissolved the time limit. That they passed Representative Jackie Spear's bipartisan bill. The Senate refused to take it up in the last session, which means we have to start all over again in this session, but we have a brand new Senate this year, and we're very optimistic in the House again that something will happen. We're expecting Senator Cardin, who is the sponsor of the Senate bill, SJ Res 1, and he will be on a little bit later in our program. Congresswoman Jackie Spear, as you may know from watching your television sets, has been a little on the pressed department lately with the impeachment and the seizure of the Capitol and all, and she sends her regrets. But Erika Osei, who is representing Congressman Tom Reed, a Republican from New York, who is co-sponsoring the House bill, HJ Res 17 this year. She's with us. And Erika, if we could have a few words from you, and thank you so much for joining us.
Hello, good afternoon. Thank you for inviting us to participate today. So Congressman Reed, like Congresswoman Spear, he regrets that he was unable to make it. At this time, I do understand that there's some press on this call, so please consider my remarks as off the record. For a full statement, you can contact our communications director, Nathaniel Sizemore, and I'll include his email in the chat later. As an office representing over 700,000 different and unique individuals, we are opposed to discrimination in any form, including on discrimination on the basis of sex. Congressman Reed was the youngest, or is the youngest, of 12 children. He has 8 sisters and 3 brothers, and he was raised by a single mother on a Social Security check, Betty Barr Reed. So Betty taught Tom of the unique power and strength of women, both in America and around the world. And he's proud to support this legislation. You know, not only that, but we have a rich background in the 23rd District in the fight for women's rights. We have Seneca Falls, which is the location of the Women's Rights National Historical Park in our district, and it keeps the history of the Seneca Falls Convention alive. It ensures that we want to ensure that generations of future Americans understand the sacrifices made to make this country better, as well as how far we still have to go. This amendment would be not only for the thousands of women who have been discriminated against, but for the next generation of women as well. We want to ensure change, and we will always advocate for the consistent enforcement of anti-discrimination law. To that end, in 2019, we when this came to our attention, we were proud to add our name to the effort to bring back the ERA with the first congressional hearing on this important issue in 36 years. We have joined as the Republican leaders on Representative Carolyn B. Maloney's bill to restart the ratification process for the ERA, as well as Representative Jackie Spear's joint resolution to remove the 1982 ratification time limit. So this covers all bases in the fight to ratify the ERA, and we joined onto these bills again in the 117th Congress. And we will continue to fight on a bipartisan, bicameral basis on this campaign as we work to ensure that this historic amendment has a fair shot at being enshrined in our Constitution. Again, we want to thank Representative Spear and Representative Maloney for their efforts. And I want to thank you guys for your time and for hosting this. This is great.
Erika, thank you so much. And please send our best regards to Congressman Reed. He's really been a champion. And I love the stories of him talking about his sisters and his mom and all. We really appreciate his support. Thank you, Erika. For a closer look at what we are doing on Capitol Hill, I want to introduce now Bettina Hager. She's the Ehri Coalition Fund for Women's Equality DC Director, whose job it is to make a lot of those phone calls and to do a lot of counting. So Bettina, thanks.
Yeah, well, thank you. And thank you, Erika. Erika, prior to the bill introduction, and she, was really instrumental in helping us make this what we hope to be the year of the ERA by ensuring that the ERA is currently both bipartisan and bicameral, meaning that both the House of Representatives and the Senate have introduced a bill to remove the time limit from the ERA with support from both Democratic and Republican members, which is so important right now. One of the things that we heard from the AGs and from Linda and Jessica was just how important it is, although not necessary because all the constitutional requirements have been met for the ERA to be the 28th Amendment, but how important this bill can be in ensuring that when it gets to the Supreme Court or whatever court it's at next, that this is not an obstacle. And it's one of the obstacles that the opponents do like to bring up, that Congress voted to put a time limit on the preamble. But our argument is that while that may be true, they can also vote to take it off. So that's what we're asking. And we do feel that 2021 can be the year of the ERA. And I want to thank everyone for being here because your advocacy will be crucial to seeing that become a reality. So just a little bit more of the in the weeds. Currently, HJ Res 17 is the bill in the House of Representatives. It has 202 co-sponsors. It is co-led by Representatives Jackie Spear and Representative Tom Reed, who Erika is representing his office. In the US Senate, it was introduced as SJ Res 1, which is a big deal. It was introduced by Senators Ben Cardin and Lisa Murkowski, who chose to do it as their kind of day one legislation to show what a priority this bill is for them. The goal that we have right now for the House is to see it get through to a vote. I'm sorry, I just kind of stepped in March of 2021 during Women's History Month. And the way that we plan to do that is through a continued co-sponsorship drive. We need to get all of the remaining members of the Democratic caucus who supported in the last session, moderate Republicans and newly elected women Republican members on the bill. We do have target sheets and co-sponsor toolkits, which we'll be happy to share with you. And then the other thing that Jessica kind of touched on is the importance of positive pressure campaigns to House leadership and to current co-sponsors, kind of showing the broad support for the ERA. Our goal in the Senate is similar yet slightly different, as we are also pushing for a floor vote in 2021. But one of the things that's been mentioned additionally earlier today is the idea of the filibuster. So we know that we have enough votes, if it were come to the floor tomorrow, to get a vote in support of SJ Res 1. Unfortunately, we don't need just 50, we need 60. So we are creating a roadmap to 60 votes. And to do that, it's slightly different. We are going for a strategic co-sponsorship outreach of Senate targets featuring constituent outreach and credible messengers. So for the Senate strategy, we're really focusing a lot on getting op-eds, LTEs, and just positive pressure from constituents and GOP influencers. We're also going to be working on a positive pressure campaign to Senate leadership and our current co-sponsors. And then, as I mentioned before, we do have co-sponsorship toolkits and social media share kits. One of the things that I skipped over that I want to go back to is just to highlight what the text of the resolution actually is, because we always talk about removing the time limit. And yes, that's kind of the summary of what we're doing. But in reality, what Congress is doing is it's voting to say that once 3/4 of states have ratified that the article of the amendment passed in 1972 shall be deemed valid to all intents and purposes as part of the United States Constitution. So we feel that once Congress votes to do this, then basically it's sending an affirmative message that it's done. Their work is done. Congress feels it's not just removing the time limit, it's affirmatively stating that in Congress's mind, this has become a part of the Constitution. So I just wanted to highlight that, because sometimes when we say removal of the time limit, in a way, we're not looking at exactly what Congress is saying through this bill. So Congress is not just removing the time limit, it is affirmatively stating that the ERA is the 28th Amendment of the Constitution. So that's kind of as far as I want to go for giving a brief up-to-date overview. I want to bring up one of my great colleagues, Steve Andersson, to talk a little bit more about strategy. As I mentioned, a lot of our strategy, and one of the reasons we're so thankful to Erika for being on here, is that a lot of our work will have to be across, will be bipartisan and across the aisle, with the Democrats being the ones who are largely making up the co-sponsor list. So we need to have a really strong strategy, and we couldn't be joined by anyone better than Steve Andersson, an ERA Coalition board member and the executive director of GOP for the ERA, to talk a little bit about how we can get this done. So Steve.
Thank you, Bettina. It's a pleasure to be here. Pleasure to see so many friends on this call that I oftentimes get to interact with. For those of you who do not know my history, prior to my current role, I did serve in the Illinois House of Representatives, and along with my then colleague Kwame Raoul, when he was a senator, we both had the honor of voting for the ERA, which is one of those things I view as a tombstone issue, something I want to carve on my tombstone and say, this is something that I did. This is something that I was on the right side of history for. But once I left the Illinois legislature, I didn't want to be done with this issue. And so I continued to fight. And now I have broadened my appeal, or my reach, to attempt to really change the narrative on the Republican side of this issue. So we have formed the Republicans for the ERA, or more colloquially, the GOP for the ERA. The idea being is that from the very beginning, the GOP really was in favor of the ERA, and it hasn't changed. You will see that the net effect of a lot of influencers has been that we have been quiet on this issue, or opposed to the issue, unfortunately. But when you look at the polling, when you look at the average Republican on the street, and you ask them about the concept of the ERA, overwhelmingly, like in the 90 percentile, Republicans support the concept of equal rights for all. So this is not a revolutionary concept. But what is revolutionary is the need to reactivate the Republicans. For too long, this has been largely a democratically led issue, and that's great because it's gotten us where we are now. But really to push us over the line, as Bettina mentioned, we really do need Republican support on this. The states that remain to ratify are largely, if not completely, in Republican control. And by the way, I'm not satisfied with 38 states. I want 50 states. So, we're going to continue to fight that. And of course, to do anything in the Senate, we're going to need 10 Republicans. So we have 2, Lisa Murkowski and Susan Collins, Alaska and Maine. And that's great, but that is not enough. So our excitement is to engage in a campaign that I have talked about for a long time called positive pressure. And you heard Bettina mention that term. That's because when you talk to Republicans about this issue, we have to remind them that it's consistent with our worldview, if you will. It's about small government, which is something Republicans like. It's about the government staying out of the business of regulating how people conduct their lives. It's about being pro-business. Every study that has looked at the issue of women's participation in the labor force, women's participation in the boardroom, in the courtroom, you name it, all of them point to the fact that doing so increases our economy. That's right, Alyssa, thank you. It's about the economy. And last, we have always been a party about equal rights, about individuals. We are the party of Lincoln, after all. So the idea here is through positive pressure to remind our electeds and our candidates for election who are ready to come out from behind that what do I want to call it, misperception about Republicans, that we are not in favor of this. We want to back them up. We want to show them that there is a groundswell of support amongst Republicans. The people who will vote for them will say, yes, indeed, this is exactly what we want. This reflects Republican values as well as Democratic values. This is something that everyone can agree on. So in the coming weeks and months, you'll be seeing our voice grow louder. And the idea, as I said, is positive pressure to make sure that we know that our electeds and our candidates know we've got their back, that we're going to be there for them, that we're going to walk for them. We'll knock on doors, we'll fundraise for them because they support the ERA. We're going to turn what some of them might have perceived as a hard vote into a really great vote. And that's the excitement that we look forward to sharing with all of you in the coming weeks and months. And with that, I will, I think, turn it back over to Bettina.
Well, thank you much. Thank you so much, Steve. And I did want to make sure that everyone knows how to connect with us to get all of our toolkits and to be connected to our Slack channel. So if you would like to be connected to us and get involved with the advocacy, I hope you'll contact Vivian Pong in our office. vpong@eracoalition.org, and we can get you connected with all of the things that we need to do to get this done this year, because we do truly believe that 2021 can be the year of the ERA if we all work together. So I'm going to hand it now back to Carol.
Thank you so much, Bettina and Steve. That was terrific. And Vivian, by the way, when you do reach out to her, she's a very affable young woman. So don't be afraid. She will be able to get you your information. The Ehri Coalition, as you may know, has sent to President Biden and Vice President Harris a letter signed by more than 200 organizations asking for first 100 days support. And we put in the chat room a petition that we've also made available for the public to sign. We had so many people who said, well, I may not be a major organization, but I do support the idea of the Equal Rights Amendment and would like to let President Biden and Vice President Harris know that. So we now have a petition up on our website. The information is in chat, but you can go to eracoalition.org at any time to sign on to that petition. Please share it with your networks. So we have in the White House, two people who have throughout their careers supported the Equal Rights Amendment, which is a slightly new environment for us, and enthusiastically supported it. So we want to talk a little bit about our relationship with the new administration. Alyssa Milano, has had a lot of contact, done a lot of work in getting this particular administration installed in office. And if you could talk with us a little bit, Alyssa, about what you expect to the results to be from this new relationship.
I mean, I think, like everybody else, I have a lot of hope. for what Biden and Harris are going to do for equality in general. And I think that the thing that is so spectacular about what they've been able to put together as far as administration is that everybody really understands the intersectionality of all of these issues and how important it is to fight for everything at once, especially when we're dealing with equality. So I think there is a lot of hope. I think the fact that he started, a women's commission that will be focusing just on women's rights, I think is really important. It was part of his initial platform before he was elected. It was part of his women's platform. So, and I read a stat that he had co-sponsored the ERA like 16 or 17 times in his career. So that is really exciting. And I think we need to fight on all fronts. So that means pushing the administration where we can, also pushing the Senate, trying to get more sponsors, I think is really important. My biggest concern, and the thing that I want us all to be mindful and thoughtful about, is we all need to have a very clear message on what we're fighting for. And that might be different than the forward-facing message, because the forward-facing message should be simple and on target. And then we can work everything else behind the scenes. But I think to get public awareness and to educate and empower people to understand the Equal Rights Amendment, we are going to really need to simplify, because right now it feels like it's lifting the arbitrary timeline. It's, the attorneys general taking people to court. It just feels like we can't message all of that. It's got to be a little bit more streamlined. And of course I'm here to help in whatever way I can, whether that's through my platform or with the Biden administration.
Right. Thank you, Alyssa. Right. People always ask me, to Alyssa's point about there are a lot of pieces of this, people always say, can you just give me the short version of the ERA? And I say, there is no short version, but I think that we can put forth, the paths as we come to them. We do understand that Senator Cardin, who is sponsoring SJ Res number 1, and thank you so much, Senator Cardin, for that. We all whooped in the so-called virtual office when we heard that we were number 1. Made us feel extremely honored. Thank you so much for joining us.
Well, Carol, thank you. It is a real pleasure to be with you. You're right. We are very proud to have Senate Joint Resolution 1 for the Equal Rights Amendment. And when we talk about the Biden administration, look, this has been a difficult period. We went through January the 6th, the date that we never thought we would see in regards to an insurrection against our country. And then on January 20th, at the same location, we celebrated Joe Biden taking the oath of office as president, Kamala Harris as vice president. And what President Biden has said, he wants to build back better, and we say fairer. And that means at long last to get the Equal Rights Amendment in the Constitution of the United States. It's been a long road since 1923 with Alice Paul's original efforts. This looks like the year we can get it done. And I've talked to Senator Durbin, the chair of the Judiciary Committee in the Senate. Senator Schumer has shown his priority by giving us Senate Joint Resolution number 1. We have total support among the Democrats, and we have bipartisan support with Senator Murkowski and others. So we are really anxious to get this going. Obviously, we were disappointed. I was disappointed on the results of the impeachment trial, but now that's behind us. So now the Senate can get back to work, and we are very anxious about it. So it's important that we keep the momentum going, and that's why I'm so pleased what you're doing today.
Senator, thanks so much. There are so many people who believe, though, that the only way that we can get this is if the filibuster is removed. Is there another path?
Oh, I think so. I think we can get Republican support. I'm talking to individual Republican members now. We are working on trying to get as much support as possible. There are a lot of different ways that we can try to work this around. Look, I'm for reforming the Senate floor procedures. I'm working with Republicans to get that done also, if we possibly can. But I recognize it's a challenge for some members of our caucus in regards to the rules changes. So we're going to try multiple paths. We want to get to the finish line.
And do you have an idea of when, as we, are starting to plan our parties already, Senator? Thanks for your hard work and leadership. But any timeline when you think this might happen in the Senate?
Well, I want to talk with Speaker Pelosi and Majority Leader Schumer as to the strategies as to whether we want to build the momentum and passage in the House first, or whether that looks a little bit too partisan and maybe we start in the Senate where we have more bipartisan support. So we're going to plan strategy. Obviously, people have been so focused on the inauguration and then the impeachment trial, and now trying to get our nominations approved for the Biden administration. So it's going to probably be a couple weeks before we can answer that question.
Oh, a couple of weeks. That's like tomorrow. Thank you for that. But also I want you to explain the way you're adding sponsors to the bill. People get worried when they don't see a lot, so if you could explain the pairing system, that would be terrific.
Sure. We're working very closely with Senator Murkowski. She wants to build support on the Republican side. So we didn't want to overwhelm with Democratic support initially. As you know, we had all the Democrats on the bill in the last Congress. There's no reason to believe we won't have that type of support in the Democratic caucus for this. We do have the public's behind this. So this should not be partisan. And we're selling it that way. And we think that by restraining a little bit of the Democratic caucus actions to get more Republicans on board is a smart way to try to get this done this year.
Terrific. So the entire Democratic caucus, and so far Senators Murkowski and Collins are on, as they were last session as well, and building. Well,
and we have a list of Republican senators that we're working on right now, and we're sharing that with you. And we have a strategy to try to get that number on the Republican side larger.
Terrific. Well, Senator Cardin, thank you so much. And thank you for squeezing us in. You were so busy and you were so terrific during the crisis. Thank you for all of your words of and terrific leadership.
Well, Carol, thank you for everything you're doing. We're going to coordinate everything with you. You've been the champion of keeping us all focused on getting this done. So stay well, and we will continue to share information as we go forward.
Terrific. Thanks so much, Senator Ben Cardin from Maryland. We interrupted our discussion of the White House so that we could hear from Senator Cardin. I would like to turn now to Ellie Smeal, who is the founder and president of the Feminist Majority, former president of NOW, activist, policy analyst, and who actually knew Alice Paul, who wrote this resolution, this bill back in 1923. Ellie doesn't really know her from the 1923 days, but she did know her. And Ellie, start by telling us, why she cried.
Well, I don't want to start with a downer, but anyway, we were active. I've been active for 50 years, so I was lucky enough to be there for the lap over where the reinforcements finally came. But essentially, she was excited that reinforcements had come. The National Women's Party, which everybody should see their museum, had been at it a long time. But at the early 70s, as you know, it gets finally through both houses in 1972. And National Organization for Women Now, which I was very active in at that time at the local level, was a major portion of the reinforcements that came in the early 70s, where we not only got, Title IX was passed in 72, as you know. And of course, this came through March 22nd, 1972. And I think what you're referring to is right after it passed the Senate, we were going to have a party at the National Women's Museum, or then it was their house, so it wasn't a museum yet, and to celebrate that we finally got it through the House and Senate. So we go to this party, those of us who were so excited. Can you imagine, after all these years, we finally get it through the Senate, finally got it through the House, but this was the Senate vote and et cetera. And we go there and she's not there. So we can't figure out what happened to Ellis. I mean, why isn't she there? So one of our members went looking all through the house, and she found her sitting at Susan B. Anthony's desk, which was in one of the rooms of the Sue Belmont house, which is where the party was headquarters. And so she came and got us. Her name was Phyllis Weatherby from Pittsburgh now. She came and got everybody and said, come on, Ellis is back at Susan B. Anthony's desk. So we go charging in there and realize she's very, very upset. We thought she was crying for joy, but she was very upset with the final wording, in which well, there's a couple things in it, but most importantly, she was upset that they had put a time limit in it. And she talked about it. And we said, oh, don't even worry about that. We're going to make it. She said, no, it's a trick, you know. It has nothing to do with the time limit. She wasn't worried about the actual time limit. She said it's a way for them to delay. And if you delay in these kinds of things, she felt that it might get stopped. And she believed that it was the workings of the Southern Democrats, and that it was a trick. Anyway, unfortunately, she had some right to be. We were novices. She had more experience. But one of the things is that I came in it at a negative because I really want to be on a positive. I think this is the year that we are going over the top. And there's a lot of reasons. In first place, the time limit has no binding. She realized that. It was just a little bit of a strategy because it's in the preamble. It's not on what the states voted on. The states voted on the wording of the Equal Rights Amendment, which would be in the Constitution. And there is no time limit in that wording at all. And that basically, she saw it as just a strategy from those who could not stop our popularity. And our popularity then was not anything like it is now. We were a majority movement, really, in the 70s too, but it was in a narrower majority. It was like in the high 50s percentiles. Now, the latest polls have something over 90% of the people believe the Equal Rights Amendment should be passed. Life has changed totally. And our support is so overwhelming that people think we have it already. So we got to make sure that people make sure that everybody gets activated. In other words, don't take anything for granted. And we have to look at both our friends and those who we think are opposed to us, because basically we will pass this with an overwhelming majority if we have that kind of positive attitude. It was something like Lyndon Johnson said on the Civil Rights Acts of the 60s. He said, I'm with you, but go out and make me do it. Well, right now, we're very lucky. The stars are aligned. We have a majority in both houses that are with us on the Equal Rights Amendment. And we have two strong advocates in the White House. We have two strong advocates with the Bidens, obviously, but I meant the president and the vice president. And when I mean strong advocates, I mean strong advocates. The vice president has not only sponsored the ERA, but let's face it, he was the architect of the Violence Against Women Act, in which we and I had the privilege of working with them on many variations of it. As you know, it had to be renewed every 5 to 6 years, reauthorized, and every time we made it stronger and increased the jurisdiction. But this is a key, the court struck part of it down right at the beginning. It denied a civil right of action for a woman to go into federal court herself against her abuser, or to go into court against perhaps a police department or a university that was in fact, by its rules and regulations, contributed to her abuse. Let's put it that way. And we have wanted, and I keep saying Senator Biden, President Biden wanted that to be reversed, that it's a very big mistake. It limits the power to enforce the Violence Against Women Act. Well, the Equal Rights Amendment will give it a constitutional basis, banding sex discrimination in a constitutional basis, not just a statute, not just an act, but something that is permanent and something that makes it and it puts it in the highest law of the land. So I want us to center that, because I want people to understand it does and it will help women and, well, frankly, all people, women, men, transgender, a whole LGBTQ community, but it'll help people because it says you cannot deny rights on the basis of sex. Very simple. Now, anyway, I think that we got to make those polls that show us over 90% come to life. Make sure that everybody sees that big majority, but we got to do it fast too. We want to pass it in the House. And frankly, I would love to pass it in the House and the Senate by the end of March, Women's History Month. Wouldn't it be just marvelous? Wouldn't it be just, think about it. We'd have in the Senate, I'm hoping Kamala Harris will be sitting there in the chair, presiding, the first woman vice president, and ensuring that equal rights are for everyone. And then basically, obviously, the woman Speaker of the House. I mean, Pelosi is just, as we all know, just a national treasure. So basically, I think that if we got to make these petitions, just keep growing. And all of us stay positive. My goodness, this is no time to go backwards. And one thing is, when I say the stars are aligned, where we have the right people in the White House and we have majorities in both houses, we also, the pandemic did something that all our years of activity could not do. It shows beyond a reasonable doubt that women workers are essential workers, and that they deserve full and equal rights, that all people deserve full and equal rights. And I think that basically with this pandemic in the background, I think it just shows you, it reveals the discrimination. It reveals that so many of these women workers are working at a minimum wage that is not livable. It shows that we still dealt with childcare. We don't have enough early childhood care. We don't have enough, we don't give people credit for caregiving years to either the elderly or to children. In other words, our policies and our laws have discriminatory factors in them. And we need this Equal Rights Amendment. It will make our country and our economy more healthy.
Wow, Ellie, thank you so much. We're so lucky to have you in leadership. We got to work on that letter to President Biden together by many phone calls and whatever. I think, we became so attached to each other. It's midnight, we're still working on the letter. I said, no, Ellie, we want to hear your optimism. This is it. This is the year. Thank you so much.
Thank you.
Another person engaged in the letter writing is Lisa Sales, a member of our coalition and chair of the Fairfax County Commission for Women and the Virginia Sexual and Domestic Violence Action Alliance Policy Committee. Lisa, thanks for being here.
Yeah, thanks for having me. So happy to be here with all my soul sisters and the men that support us. And Ellie gave me a great segue because we have other advocates in the White House through the new Gender Policy Council, the GPC. I think they named it that for two reasons. One, because it's sort of akin to the DPC, which is the White House Domestic Policy Council. And if you'll notice, for the first time ever, we started with our first ever women's office, if you will, at the White House back in the Clinton administration, and it was called the Women's Outreach, had outreach and initiatives in the name. And then in the Obama administration, it had White House Council on Women and Girls. And now it's the Gender Policy Council to be more inclusive and to welcome transgender women, transgender people, LGBTQ, non-binary, non-conforming folks. But what you'll notice that's different this time is that policy is in the name. And those of us who are on the Biden domestic policy teams were very insistent that we be drivers of policy and not just outreach and initiatives. And of course, outreach and initiatives is an important part of everything we do, but women shouldn't be relegated only to outreach initiatives. And so very, very proud of the advocates we have by way of Jen Klein and her partner over there, Julissa Reynoso, both co-leading the Gender Policy Council. And so I think there will be, this will be a more policy-driven effort. I think the GPC could advocate for the ERA by stationing people in every federal agency and asking them to conduct racial, pay, and equity assessments to assess whether marginalized groups, really anyone, are discriminated against, and whether there's a diverse female representation at all levels of leadership, including judicial diversity, just as they did with the cabinet. So that's what I expect to see and hope to see. The GPC could also review administrative law and policy with the ERA in mind, reviewing language, whether it be pronouns or looking for discriminatory prose in any of the current federal law. So I think, as I said, Ellie gave me a great segue, and many of you know that I made the association of our lack of equality with the violence we experience, and as a survivor became very engaged in the Equal Rights Amendment. And so this is our VAWA president, and I think they most definitely, right, you can count on it, will revisit equality in terms of the Violence Against Women Act. The president has said this is legislation he's proudest of. So I think we'll be looking at equality from that angle. Obviously, our Black and Brown sisters are disproportionately impacted by violence, LGBTQIA. You know, we were so close in the 116th Congress, but we couldn't get it off Mitch McConnell's desk. And now there's real hope that we can budge that and get it over the finish line. And I'm with you, Ellie. Women's History Month is right around the corner. Wouldn't that be wonderful? So we all know too, there's been a tremendous backsliding of women due to the pandemic. I think we lost something like 5 million jobs in 2020, and they're saying it's going to take so much time to make up all of those gains. And many don't realize that something like 50% of women are heads of households with children, and the bulk are living in poverty in this first world nation. So I think they'll look at economic security for women and girls. They'll look at foreign policy, healthcare, racial justice, again, gender-based violence, foreign policy, and adding, I'm hoping that they will really engage and are constantly whispering in the ears of our, new administration, like, let's get this ERA done. I think they'll look at sexual harassment seriously. In fact, they moved out with a no nonsense approach in the Department of Defense on day 2 with SecDef Austin, who issued a 2-page memorandum immediately on sexual harassment and sexual assault in the military. So they have a lot of work cut out for them. I think they'll look at pregnancy discrimination. And so a lot of things that the ERA will undergird, I believe they're going to start getting going on, right? Fair pay, paid family medical leave, and definitely this huge care crisis we have. We need a care infrastructure. Mothers of small children were 3 times as likely to leave the workforce than their male counterparts. Obviously, you heard the discussion in the news about the minimum wage, Title IX enforcement, and absolutely rolling back Betsy DeVos's actions will be huge. Student debt is another area. Not many folks realize that women have 10% more student debt than men, and they take longer to pay it off, are more educated, yet paid less. So we're hearing there's some movement on student loan forgiveness as well. Unfortunately, those with over $100,000 or upwards of 75, and in public service, it won't do a lot. So there's been talk about forgiveness overall, access to healthcare, and better data collection, making so that we can make more informed decisions, taking a closer look at discrimination, violence against women, and collecting all of that data. It's something I'm working on currently at the Pentagon in my current role. And I think we're looking forward, all of us, right, together, having a enshrined ERA and looking forward to a time where we don't need councils devoted to the rights of women, that we're all just equal.
Great, great. Lisa, thank you. Thank you so much for that. And Jen Klein and Julissa Reynoso are friends of the coalition, and we hope to have a program where they can come and talk with us as well. They said it might have been a little too early today. They don't have their offices yet, but
they'll be much better than me.
No, thank you. No. That was great to get the preview. Lisa worked on a lot of, putting those plans together. So we'll look forward to in subsequent, this is only the first of several briefings that we hope to hold. So there are a lot of people who say, and who always ask, knowing that the ERA in its first blush refers to the federal government and state governments, and who sort of minimize that, like, well, what difference does that make? Well, there are millions of people who work for the federal government, all the contractors, all of that we intend for the Equal Rights Amendment to affect that. And every single state will have to look at their statutes and in so many cases rewrite them. There's a ton of work. We were so thrilled when Diane Post, who's in Arizona, brought to us the work that they had done there, examining the Arizona statutes and what has to be changed. So at this point, I'd like to introduce Diane Post. She's an international human rights lawyer, a board member of ERA Task Force in Arizona, and Mala Clancy, who's senior counsel Perkins Coie, and to talk about the Arizona statute review. It's called Equality is for All. Equality is for all. And you know how many pages it is of the numbers of things that have to be changed? 652 pages. That's a lot of work. Diane and Mala, thanks so much for being with us today.
Hi, I'm Diane. And the idea behind it was, of course, the second section of the ERA says it doesn't go into effect for 2 years. Well, 1 year has already passed, so we're on the second year. Our idea was that we would review all of the Arizona statutes and give it to our legislators so that then they would have the language to change the statutes. Well, we had hoped for a different legislature this year, and unfortunately, we didn't get it, but there we are. So now it'll be ready for 2022. So the first thing I did was talk to the state legislative council head attorney, who happens to be a woman, about how she best wanted it done to make it easiest for her. We got a great editor whose profession was doing this. I sent out announcements to all the women lawyers groups and to the big firms that I knew had pro bono departments to ask them for volunteers. We got 24 lawyers who volunteered and 22 who delivered, and we tried to focus them on the statutes or the chapters that they knew about. So they didn't have to relearn their topic, they just had to read through them. And we read the entire thing. And then we changed it in the way that we thought from a legal point of view. We disregarded the politics, we didn't completely disregard the legislative council, how they want to do it. If they want to change it, they will, but we disregarded the politics and did the best lawyering that we could do on that. The only one where we had a bit of a not difficulty, but discussion necessary in order to come to an agreement was in the criminal law. Because in Arizona, we have a lot of criminal law against women. Nudity, prostitution, obscenity, abortion, birth control, you name it, we've got laws that would harm women. And it was sometimes difficult to figure out exactly how we wanted to rewrite that to the best we could. Well, we did it. We had a couple of Zoom meetings and we came to our conclusions. So then our editor with some proofreaders, also volunteers, everybody in this proposal was volunteers, every single one of us. We had 4 proofreaders plus the lawyers, 2 of whom were proofreaders, et cetera, and none of us were paid a dime. So it was all volunteer. We wanted to do it in by the fall, because in the fall is when the legislative council needs the documents in order to prepare all the legislation for the attorneys. So I'm not for the attorneys, for the legislators who start in January. So it was done in 4 months and we had it ready by September. And then of course, when November came, we didn't, actually it was November before we actually finished it. It was November. But then of course, the result of the election were not what we had hoped. So it has been used in a small way, but it'll be more later, it will be used. So Perkins Coie and Mala was a firm that responded with their pro bono department to help. They had 6 lawyers who did 8 chapters. So Mala, I'll turn it over to you for a few words about your process.
Okay. So can you hear me? I don't know if I unmuted.
Yes,
yeah, I did. Okay, good. Okay, good. Hello. Yeah, it was an interesting project. We all had a little bit of trouble sort of figuring out what we were supposed to do until we started reading our statutes and realizing how really antiquated they are. There's a lot of him, his, especially I did the chapter about professions and occupations, and so not surprisingly, the physician sections, the real estate department, which is my area, that's a man. They had it I think he's called commissioner. He or she is called commissioner. He throughout. Physicians, he throughout. When you get to the nail technician section, licensing and so on, there's no gender used because that wouldn't be a he, I suppose, in people's minds. So it was interesting to find out how, like I said, antiquated the statutes are and how kind of jarring it is to read he when you're reading about a doctor or another kind of stereotypically male profession. You hit the word he and his and you realize our thinking has changed, but our statutes have not changed. So that was a real learning experience for me. And you do realize how these sex identity, these terms are really sprinkled throughout and do need to be, neutralized. So it was a great project. Thank you, Diane, for heading it up.
Right, right. And specifically, you said that there are laws that discriminate against women particularly. There's you can be arrested for being nude if you're a woman, but not a man. Is that the...
Well, it's a display of the breast. Men can display their breasts, but women, it has to be above the nipple. But one of the ones that was so shocking was there was still a law, there still is a law on the books saying that married women can sign contracts. So the woman who reviewed this was a young lawyer and she called me up and she said, I don't even understand why is this in there. And I laughed and I said, because you don't realize that in the past, married women could not sign contracts because they were appendages of their husband and only the husband could contract business deals. She was just shocked and said, oh my God, we got to fix this stuff. So it was a great educational experience for a lot of the young attorneys who had no idea that some of this stuff was still in the statutes.
And so Mala, what do you think has to happen? It's you created the model for the states, and the same thing has to be done for the federal government.
Right. I mean, and every state, you know, I suppose has to look back at their laws. You don't think about it until you start delving into it. I read statutes constantly. You know, unless it's one of those jarring references, you don't realize what you're reading. You know, you're sort of, that's not your focus, the pronouns. It's you know, the substance of the statute. So I think, you know, states need to look at this. It's, you know, like this young lawyer, and I'm not one of those young lawyers, but the young ones, they don't realize, you know, that this is how things were. This is how, you know, thinking was. Today, it's not like that. That's why it is so jarring when you see that. I think, you know, everybody needs to analyze their laws.
So all of the laws that are in existence have to be analyzed. And then there's the prospect of writing new laws. Diane, I know you must have an idea. What's your first law that you want to see written out of the Equal Rights
Arizona still has criminal abortion law in the books. We never took it off. So that's the first one. And we've done it for years and we've not been able to pass it, and we won't pass it this year either. So that's the first one, but there are many. And the family law attorney was shocked when she found a provision that said, if a mother uses drugs for a year after the birth, they take the child away. If a father uses drugs for a year after the birth, of course they don't.
Huh. Well, fascinating. And I think we put it in the chat. Diane and Mala have said that this is available for everybody to take a look at as an example. Take it back to your, you know, to your state. So we have a lot of work to do. Thank you both so much for, you know, for that and for bringing it to us, Diane and Mala. At this point, I'd like to introduce Dr. Julie Suk, who is a member of our legal task force. She's at CUNY Graduate School and Yale University. She's the author of The Unstoppable Mothers of the Equal Rights Amendment. And she has a fascinating new essay on Pauli Murray. It's called A Dangerous Imbalance, Pauli Murray's Equal Rights Amendment and the Path to Equal Power. I think Julie has revealed so many things about the movement, who was involved in it, and especially women of color, Black women. Julie, thanks so much for being with us here today.
Oh, thanks so much for having me. I'm just putting my book in the chat because I will just tell you a little bit about some of the research I've done in writing this book, We the Women, about the 100-year story of the women who made and are making the ERA. And I would say, Carol asked me to say a few words about the future. And I think, and I'm going to speak from the standpoint of a constitutional law scholar who has also spent much of my career teaching procedure to law students, as well as constitutional and comparative law, that I think that at least from the constitutional law, scholarly and law school community, so much of the controversy about the ERA centers on two questions. Nobody really doubts the importance and desirability of having equal rights for women in the Constitution. We're not fighting about that. That seems unassailable enough. But one thing that is very important to lawyers and to law professors is the concept of procedural justice, and the idea that how you get something makes a difference to what it can possibly be. And I think with regard to the ERA, the problem with the deadline is that if it's true, it is true that many of the amendments that we've had in the last 100 years had that deadline, the 7-year deadline, and nobody questioned it. And so the idea now that we're going to say deadlines are not constitutional, while it's a reasonable argument, it's one that I think does raise some eyebrows. So there's a lot of work that has to go into why is it that this deadline can be removed? Why is it that Congress has the power to do it? And even as a strategic and political matter, what do we gain from removing a deadline now? And part of what I try to do in the book is to show how the long struggle has to do with a structural problem that our Constitution had. Our Constitution was not inclusive in 1787. There were 55 white men who were our founders. And they did not assume that African Americans or women were part of the legal persons and citizens assumed to be rights bearers when they adopted the Constitution. And they wrote an amendment rule that made it very difficult to change. You had to get such a huge supermajority of people who were already in power that it seems nearly like a paradox or an impossibility that people with zero power and who were cut out of power deliberately now have to use this process, a supermajority process in Article 5, to seek their inclusion in the Constitution. Something which I think all the attorneys general who spoke earlier said it should just be natural that all of us, women, African Americans, indigenous peoples, people of color, have these inalienable rights to begin with. But even that, though that might seem natural, it was not what was put into the Constitution, and the means that the Constitution gave us for changing it made it nearly impossible for those without power to get any. And so that takes me to my work on Pauli Murray. There are pieces of the Pauli Murray in the book, as well as in this essay that was in the Virginia Law Review online just a couple weeks ago. Pauli Murray was a pioneering civil rights attorney, and the late Justice Ruth Bader Ginsburg credited her with being the intellectual architect of the sex equality litigation strategy that RBG implemented with great success in the 1970s. And this is the second major issue, I think, that comes up amongst legal scholars who are generally very sympathetic to gender equality. They ask, do we really need an equal rights amendment given that RBG succeeded in getting sex equality protected under the Equal Protection Clause to some degree? And I think here Pauli Murray's work is so helpful because Pauli Murray testified, an African-American civil rights attorney who helped shape the gender equality equal protection strategy in the 70s. She testified in 1970 before the Senate Judiciary Committee. She had a written statement in that testimony explaining why, first, she thought that Black women had the most to gain from the ERA, therefore dispelling any notion that the ERA was really a white woman's project, that it was really going to work to the advantage of all the most disadvantaged women and disempowered women, because what it offered that was different from the project of the Equal Protection Clause was a project of equal power, women's empowerment. So it wasn't just about changing doctrinally the things in the law, you know, the he's and the she's, or the absence of she in the law, but rather providing a path by which women, by advocating, became constitution makers. Women inserted themselves into the political and legal process by advocating and fighting for the ERA. And that it has enabled over time, overcoming what she called a dangerous imbalance of power. So many institutions where women are not represented, even though they have the right to vote. And you see that process playing out through historically. It's not a coincidence that the people who led the fight in the 3 states, in Nevada, Illinois, and Virginia, getting those 3 ratifications, late ratifications, but 3 ratifications in the 21st century. I believe that those ratifications could not have happened without the leadership of Black women in those legislatures as primary sponsors of the ERA ratification. And the fact that they were making it, and not just that they did it, but what they said about why it was still necessary. So the things that were unfinished by equal protection litigation, including making sure that women did not face disadvantages because of their role in reproduction. That is, as mothers, that single mothers were not disadvantaged in the labor market. And this is how all of these things come into the project of the ERA, not just as striking down sex classifications in the law, but really empowering legislatures and lawmakers all over the country at the federal and state level to change laws in a way that brings real equality on the ground. And that's something that all of the women who have advocated for the ERA in the state legislatures have lived, because they're not just doing the ERA, they're also doing Pregnant Worker Fairness Acts. Senator Spearman is introducing a bill in Nevada to make sure that corporate boards are gender equal. There have been efforts to make corporate boards gender, at least one woman on every corporate board in California. And now conservatives are using the Equal Protection Clause to challenge efforts to promote women. And I think this is another area in which an equal power understanding of the ERA that we can attribute to Pauli Murray can come into play to really do the unfinished work that the Equal Protection Clause has been unable to do, largely because the Equal Protection Clause evolved after a lot of RBG's successes in the 70s. The Equal Protection Clause evolved and ended up being used to strike down race-based affirmative action, strike down efforts to actually promote equality. And so this is where I think the process matters. It's not just that we get an ERA today, but that we have opportunity to say what it means. I think that hearings in both of the congressional committees, the House Judiciary and Senate Judiciary committees, are still important, not just the vote. That is, hearings in which people can say why it's necessary, how it's different from the Equal Protection Clause, and who is making the ERA happen. So it's my hope that we will get the ERA that's worth fighting for by making sure that the process that is used creates opportunities to create those meanings.
Terrific. And Julie, are you optimistic that it's this year? Why do I ask that question of you?
So I have been engaged, and one of the things I discussed in one of the early chapters of the book, and I saw that someone put something interesting in the chat about it as well, is the origin of the 7-year deadline. Because the 7-year deadline really would not be there if there were just a few guys who really wanted it, right, who opposed the ERA, and they used an implied threat of filibuster to get that 7-year deadline in there. Right. They were known filibusterers. They had filibustered the 1964 Civil Rights Act. They were segregationists. So everybody, there were over 90% of both houses of Congress supported the ERA, but there were these guys who were strong men who knew how to use the filibuster to their advantage. And they used that, and so the ERA supporters just relented and agreed to a 7-year deadline. And I believe that so I think that the filibuster is a long-term problem that gives minorities and usually strong men who are willing to be a pain about something the opportunity to block things that 80% of the population, men and women, want. So I think that is a big question that goes beyond the ERA for policymaking in this country and legislation, certainly COVID relief and other things that are gender salient and important. So I do think that it is worth drawing public attention to the way that the filibuster is used to undemocratic ends. And I think the blockage with regard to the ERA, when we know that both houses have the majority votes to support ERA deadline removal, if it doesn't happen because of this threat of filibuster or implied threat of filibuster, I think that is a tragedy for American democracy.
Great, Julie Suk, thank you so much for being with us today. At this point, I would like to bring our chairs into the conversation. Mona Sinha, Kimberly Peeler-Allen. Alyssa, if you'd like to join in this conversation as well, if we still have Alyssa with us.
I'm here.
Great, join us. So would love to have your thoughts about what you've heard. We should say to everyone that when this organization started, we thought that we would get the ERA and then everybody would go on to whatever their next thing was in life. And then we realized that there were years and years of hard work ahead to actually implement it, to put it in place. So just, Mona, what's going through your mind now in terms of what we've heard in the update so far and the work to be done?
Thanks, Carol. So much. This is such an important conversation, and I'm so grateful for everybody who made the time to be here. I was making notes as I was listening to people speaking and listening to Attorney General Herring. The weight of history is with us. Yes, it really is. The time is now. The personal stories, so many stories of single mothers and sisters and grandmothers who have tirelessly, fought for equal rights and have really faced so many challenges in bringing up children and grandchildren. And it's the same narrative we're seeing today as women are, unfairly bearing the brunt of COVID-19, unemployment, job losses, childcare, education, just everything. Attorney General Kwame Raoul saying his daughter should be able to fulfill her dreams without discrimination. Yes, absolutely, she should, and so should every daughter in our universe. Steve Andersson, this is a tombstone issue. I love that. Steve, I'm going to steal that quote. This is my tombstone issue, absolutely. None of us can rest at peace if this does not get done. Senator Cardin, we're coordinating everything through you because you're the leaders in this work. Let's recognize the work that we're all doing together. Lisa, we should be the drivers of policy, not just advocacy. Absolutely. And Julie, what a beautiful way to wrap up, that the supermajority doesn't need to just push for the right, we deserve the right. So just in thinking about what next, if the ERA does get codified this year, what does it mean for us? What does it mean for us to hope for an equal future where democracy can thrive? And, can we have equality in the field of education, in the field of health? Can we be safe under the rules of law? Can we have legal rights? And most of all, can we all have economic empowerment so that we can make our lives be the fullest and richest that we can live? So thank you for all being here. I pass it to Kimberly to close us out.
No, thank you. Thank you so much for everyone's words. Just such an inspiration today, and really, to quote President Obama, I'm fired up and ready to go, because this is, there's so much that has been discussed about, and the parallels between the fight for the ERA and things like the Civil Rights Act and VAWA. And, we have seen that just because there has been a law passed, there has been a legal remedy, the work continues. And so much of that work is both enforcing the law once it is actually codified, but also the awareness of, who knew that if you went through all of the statutes in the state of Arizona, that you would end up with almost 700 pages of just changes, from around gender pronouns. And that's not even getting into the implementation of it and how the ERA would actually be lived in the state. So thinking beyond and really talking about what the ERA will do. I think that is the real piece, because I remember when I first joined, when I met Carol many years ago, and she said, I would love for you to become involved in the ERA. And I said, the ERA was a laugh line on Murphy Brown when I was in high school. And, it was not something that I even really thought about that it even existed or was needed. And through talking with her and meeting the other board members and spending time with Jessica and really doing my own study of the ERA, then I really was able to connect the dots and was able to really commit to this work, because there's just so much work that needs to be done to bring awareness and inform. So as you leave this call, think about five people, not just women, but 5 people that you can speak to about the ERA and the importance of moving in this moment and the impact that it will have, not just on the lives of women, but of all Americans in this country, about making sure that everyone has equality and how it is an intersectional effort that will actually help us really achieve the dream and the aspiration of this country. So it is, I'm so excited about the moment that we're in, about how we can build moving forward, and what the possibilities are, not just for my daughter to achieve equality, but for my son, for him to see his sister and his friends as full. He doesn't realize, that we are not full citizens yet. And to explain that to a 6-year-old is baffling. So we need to think about that. Our kids just have this basic understanding of things, and to get into the nuances of actually, no, we are not all equal under the law, really creates a lot of questions. And, we as adults need to understand, be able to answer those questions. And sometimes those answers are not what they should be. So let's work on that and be able to answer our children as to why all people are truly created equal in this country.
Thank you, Kimberly and Mona. Alyssa.
Yeah, I would like, I feel slightly, I'm inspired, but I'm also slightly angry that we even have to have these conversations still, and that this is something that we have to strategize like it's not, our inalienable rights. And so as we leave today, I think one of the most important things for me, for everyone on this call, because we have such incredible people on this call to think about is, we really need to streamline what the plan is and what the messaging is around that plan, so that we can have a really clear and concise answer for people when they're like, but the 14th Amendment covers women, because that's the number one thing is like, why do we need that? That's what I hear. So although I feel like we're closer than ever, I feel slightly confused as to like what the objective is right now and what the time frame is. We went from next week to 2 weeks from now, which doesn't really give us a lot of time to enlist, the people that we need to enlist. So
Alyssa, thank you. We are, this is one of those times when it's all of the above. All paths are leading at the same time, unfortunately, because we are a coalition, and but I think with your voice, we would love your amplification and your guidance. And
always.
I know you have been such a terrific supporter of ours. Remember those 6 people in a room, Melissa, right?
I remember, trust me, but that's why we're so close. I want us to have a really distinct plan so that we can see this over the finish line.
We absolutely will. So thank you all so much for being with us. I want to be respectful of everyone's time. I want you to uplift our petition, if you can share that with your networks, so that we could get as many thousands of people as possible writing to the Biden-Harris administration and asking for, for their leadership in getting something done within the first 100 days. That would be fantastic. And please go to our website, eracoalition.org, to see everything that we've got there. And we will let you know when the next briefing is. Thank you so much for joining us today. And we have to understand that equality belongs to all of us. We need an equal future for our children. And this is the only way really we can get it. The Constitution is the system. And unless we change the system, we won't be where we want to be in terms of everyone on an equal playing field. Thank you all so much. You're fantastic. We'll see you at the next one.